Thanks for that very generous introduction. Some people would say you've been at this for 30 years and it's worse than when you started. And you might be right. I don't think it's all me, though. I also am very grateful to Camille for not doing what somebody did who introduced me the other evening. I was speaking at a dinner, and as we were waiting for the time to come, my host leaned over to me and said, would you like to start now, or shall we let them enjoy themselves a little longer? And recently I was giving a talk in Vancouver, and I'd been in residence at a college at UBC for a few days, and the president of the college said, well, Justice Cromwell, it seems like you've been here for a month. And so I started my talk by saying, well, if you know, 3 days seem like a month of just being here, this speech will seem like it's going to go on forever. So I'll try not to unduly impose on your good nature tonight. I should warn you, though, when I was appointed to the Court of Appeal from the law school, one of my faculty colleagues quipped that my appointment from the law school to the Court of Appeal had enriched the intellectual atmosphere of both places. So how much I really have to add to your deliberations, I don't know. But one other thing, just by way of introduction, I certainly second all of the comments that have been made about the organizers, and well done, and thank you so much for choosing access to justice, which I think is a subject that needs lots of attention. But thank you for two other things, and thank you to all of you. Number one, to see the large number of law students with all the pressures they're under, with job pressures and grade pressures and assignment pressures and so on, to take the time to devote themselves to an important subject like access to justice is extremely encouraging. And so, congratulations. And the other thing that I very much appreciate is having an event of this nature in a more public place, because one of the things that I think about access to justice is that we do need to have a broader public conversation about what I believe is an important public issue. So a double thank you to organizers, attendees, and for the way you've staged this evening. Now, I'm going to speak about access to civil and family justice, so I'm not going to get into the criminal law. And I'm going to try to answer quite briefly 4 questions. Question number 1 is, what is access to justice? And I'm going to pause over that question just for a few minutes, because I think it's important for us to have some understanding of what we're trying to achieve. And I think that it's a much broader enterprise than sometimes we make it out to be. Secondly, why should we be concerned about it? And I think I'm sort of, what do they say, preaching to the choir on that one, likely in this room, but I will say a few comments as well about why I believe that this is an important issue that should be getting even more attention than it already is, both within the legal profession and beyond the legal profession. Thirdly, I'd like to just take a couple of minutes and tell you some of the things we've been doing to try to improve access to civil and family justice. And then finally, I'm going to come back to what you can do, both as individual members of the public and members, many of you members or future members of the legal profession. So let me come to the first question, which is, what is access to justice? What do we mean by that? Or as I've sometimes put it with our committee, how will we know when we get there? And I think a couple of initial comments. Number 1, obviously we're concerned with 2 concepts. One, access, and the other, justice. And the important thing, I believe, is to take a very broad approach to what we mean by access to justice. And what we've said as a working definition in our work is that people will have access to justice when they have the resources, the skills, the knowledge, and the services to meaningfully address their civil and family justice needs. You'll notice a couple of things about that. The first is it doesn't mention the word courts or lawyers. And it's not because we think that courts and lawyers aren't a big part of this, but we think that meaningful access to justice for a lot of people is not ultimately going to be about access to a courtroom, but access to other kinds of services that they need to meaningfully address their particular problems. And of course, the barriers to access to justice are many. It's not only economic, although that's a big part of it. We have educational barriers, cultural, linguistic, geographical barriers are very significant in Canada. And so we have a whole host of challenges to making that sort of meaningful access work. It got summed up for me very nicely in a presentation not unlike this one, where one of the participants in a breakout room said, you know, access to justice is often more about getting a babysitter or being able to get a bus pass than it is about having an opportunity to go into a courtroom. And I think that is a perspective that we really should keep in mind, that while of course our formal system is very important and has to be kept strong and vigorous and open, but there's a lot more to access to justice than thinking about everybody being able to run off to court whenever they feel like it. Obviously, that is the opposite of access to justice. Access to justice can't be the unlimited use of public resources inappropriately. And so we have that balance that we have to achieve in our access to justice work. Now, of course, access to justice engages our conception of justice as well, and I'm not going to get all philosophical with you on that. Sorry, am I sort of coming in and out? Is it okay? Does anybody care? No? I did have that experience one time. I made the mistake of saying to a group, can you hear me? Is anyone having trouble hearing? And somebody at the back put up their hand, and somebody at the front said, could I change places with you? So if you are having trouble hearing and want to hear, do let me know. But anyway, to talk about our conception of justice, obviously what we're not talking about is simply access to a formal process. But access to justice is concerned also with fair and practical outcomes. Interacting with our formal system is that they feel they go through a great deal of process, and at the end of the line there isn't a sufficiently concrete and effective resolution of the matter. And so the conception of justice that I am urging you to think about in the context of access to justice is a system that keeps the process and an effective outcome in reasonable balance. There's an American scholar who summed this up very well when he said, you have to make the form fit the fuss. And that's, I think, a kind of a neat alliteration way of talking about how the process has to be proportionate with what's at stake and has to be able to produce a practical outcome and not just a lot of paper and a lot of jurisprudence. So access is not just concerned with availability of the formal process. It includes the knowledge and skills as well as resources and services needed to meaningfully address legal problems. And it certainly does not mean unlimited access to formal process, but it means rather a just and effective outcome at the end of the process. The second question is, why should we be concerned? And I'm not going to dwell on that because I know many of you are deeply committed to access to justice in its various forms. But let me just touch on a couple of points. First of all, what we mean by access to justice and why we think it needs a lot of attention is that there is a large and growing gap between what our system of justice provides and the ability of people to meaningfully access what it provides. And Dean Cameron mentioned our report that came out in October 2013, and it's available on the website of the Canadian Forum for Civil Justice if anyone would like to have a look at it. It's not a lengthy or highly learned document. It's, I think, quite accessible to anyone legally trained or not. And the action committee that put this report together was probably the broadest coalition of justice system people that's ever been assembled in Canada. Plus, we had also some public input as well. So we're talking about a committee composed of deputy ministers of justice, of leaders of virtually all the legal institutions in the country, lots of rep from public legal education workers, pro bono workers, legal aid folks, chief justices, chief judges, and presided by a judge of the Supreme Court of Canada. So I just give you the sort of lowdown on who's talking. I'm going to read one paragraph from the report. But these are the leaders of the system talking. This is not some kind of, lobby group that's trying to stir up trouble. These are the people that are actually every day of their working lives trying to make this system work better. And here's what we said, and everybody who was on the Action Committee, about 35 of us, agreed with this report. And here's what we said. There is a serious access to justice problem in Canada. The civil and family justice system is too complex, too slow, and too expensive. Is anyone having trouble following this so far? It is too often incapable of producing just outcomes that are proportional to the problems brought to it or reflective of the needs of the people it is meant to serve. While there are many dedicated people trying hard to make it work, and there have been many reform efforts, the system continues to lack coherent leadership. These are the leaders of the system speaking, institutional structures that can design and implement change, and appropriate coordination to ensure consistent and cost-effective reform. Major change is needed. And my first point to you, I guess, is that if that's what the leaders of the system think, it's very unlikely that they're exaggerating the seriousness of the problem. For lawyers and law students and others working within the system, I think there are obvious reasons to be concerned. One of them is professional responsibility. I think everyone acknowledges that we all have a professional obligation to try to improve the administration of justice. And from people who are going to be practicing lawyers, I think that we are going to see a major transformation of the way legal services are marketed. We're going to have big challenges, but I think also some big opportunities. I mean, think about it this way. Over on this side, we have a whole bunch of people who can't get lawyers. And if you don't believe me, just go down to the courthouse some morning. I'm told that in some areas of Canada, more than half of the people appearing in court don't have legal representation. So there's a big group of people over here that would like to have more access to legal services. And on the other side, we have a whole bunch of lawyers who are saying that they would like to have more access to clients. So eventually, basic economic theory is that those two groups are going to meet someday. And what I suggest is that the legal profession should be helping them meet in a way that serves the public interest. So I think both from a professional responsibility perspective and from what's happening in the legal profession perspective, those of us in the system have all kinds of reasons to be concerned and should have the impetus to do something about access to civil and family justice. But of course, it goes way beyond that. The gaps in access to justice have serious effects on people needing but unable to access the services they require. And the absence of those services often leads to an array of other serious problems that manifest themselves in other domains. So social and economic problems, for example. The research is just beginning to help us understand the costs of not having reasonable access to justice. But the early research that I've read, a lot of it from the UK, is that those costs are enormous in the healthcare system and elsewhere. So in other words, I guess I could put it to you this way. If you think that providing reasonable access to justice is expensive, look at the costs of not providing it. And this is a dimension of the problem that I think hasn't really received the attention it deserves. And then, of course, there are broader social implications of not having an effective civil and family justice system. Because after all, an effective system underpins other important aspects of society, economic activity, human rights, and so on, so that you get to the point, if your justice system is not sufficiently effective, you begin to wonder whether you actually have any of those rights that you read about on paper. And so there are many, many reasons why both lawyers and those in the legal profession and everybody, who, even those who are not involved directly, have many, many reasons, I suggest to you, to be concerned. Lack of access to justice causes human suffering, may put into question the very viability of civil society, and if that doesn't justify broader concern about this issue, then it's hard for me to know what would. Let me tell you in just a few moments some of the things that we've been doing. And I'm going to talk mostly about the work of the National Action Committee on Access to Civil and Family Justice, because that is what I know best about. But in giving it that focus, I don't want to leave you with the impression that, you know, we're the only game in town. There are lots of people across the country and beyond that are very concerned about access to civil and family justice and access to justice even more generally. And so the Canadian Bar Association, for example, did a wonderful report, Equal Justice. Professor Julie McFarlane at the University of Windsor. There's some people from Windsor here. Anybody? And here, there's my, try to connect with the audience. But seriously, Julie has done some terrific work out of the University of Windsor on self-represented litigants in the courts, done important empirical work and qualitative research on their experiences, and there are many, many others. So I just want to make it clear that I'm not myopic. I'm just going to tell you about what I know about best, but there's a lot else happening. As the Dean mentioned, this group was put together by the Chief Justice of Canada, and then as the most junior judge on the court, I was, in quotation marks, invited to chair it. But seriously, I jumped at the chance because I have a long-standing interest in this area. We did some working group stuff, and then we filed our brief final report, The Roadmap for Change, in October 2013. And since then, we've had a whole series of sort of rollout meetings across the country. We convened an invitational symposium of civil and family justice leaders in Toronto for 100 people. We then had a first meeting of the new provincial territorial access to justice committees, and I'll tell you a little bit more about that in a moment. So there has been quite a follow-up to that, and we're moving towards our next meeting in early March in Montreal. So what did we come up with? And it may surprise you that we came up with more of a systemic approach to this than a concern about specific reforms. And the question, I guess, that really got us going on this was the following. Why is it that for 50 years, 100 years, whatever period you want to pick, we have had all kinds of very good studies about what's wrong with the civil and family justice system? And I've only been involved with this for about 35 years, and it seems that about every 4 or 5 years we have yet another report that says essentially the same problems that we've had for 200 years still exist, and make a whole bunch of recommendations, some of which are implemented, the rest of which are forgotten. And then 5 years later, we've discovered that things really aren't a whole lot better than they were before. And so we said, a question that anybody that's going to write yet another report about this should take seriously is why? And we called this the implementation gap. In other words, the distance between the ideas and the ability to implement them. And so we really spent quite a lot of time trying to think about why is it that we are so capable of coming up with lots of good analysis of what's wrong and proposing things that might very well fix it, and yet that doesn't seem to lead us to any concrete action. And that, I think, is a key question for anybody who wants to try to introduce change into a complex system such as ours. So what did we come up with? How come we have this gap between ideas and action? Well, I think a couple of things. First of all, it's not an understatement to say that our system of justice is very fragmented. You know that we have independent courts, we have independent lawyers, we have governments that have the sole responsibility for the allocation of public money, and so on. And all of those people have great measures of independence, and for good reason. There's a separation among these powers for good reasons, but it also creates a very fragmented system. There's no CEO of the justice system. There's no board of directors for the justice system. And so one of the problems that we identified and tried to come up with some solutions for is the fact that leadership in the justice system is very diffuse, which makes it extremely difficult to have a coordinated approach to reform. It's a very difficult system to get aimed at something because of all the different players. And so we came up with some ideas about how we might address that, and I'll mention those in a minute. Another thing, though, we came up with is we did some reading about change management. And why is it that efforts to change complex systems often fail? And as many of you probably know better than I do, there is quite a bit of literature on that subject. And some of what that literature says is that the single most important thing about a transformation effort is instilling in people a belief that change is needed. And so we have spent quite a bit of our effort in the Action Committee simply trying to do that, to get people to understand or to share our view that significant change is really needed. And believe me, I have been at meetings where senior justices would look at me and say, "It's not that bad, Tom. You know, I mean, sure, there are a few problems here and there, but we have the best justice system in the world and everything's fine." And I'm afraid my response to that is, well, I'm afraid you've got to get out more. Because while of course our justice system has many strengths, we take for granted things that people are dying for in other countries. And so I don't mean to in any way dilute our accomplishments or how important all those things are. But the fact remains that our civil and family justice system literally doesn't exist for an alarmingly large percentage of the population. And until I think a lot of people really understand that and believe it, it's going to be very tough to get change. And I'm seeing that happening. I think I've been at this 6 or 7 years now, and when I started those conversations about, oh, come on, take a Valium, Tom, it's not that bad, those conversations are many fewer than they initially were. And I think more and more people are recognizing the seriousness of the problem. It's certainly penetrated the levels of ministers of justice nationally in a way that it hadn't 5 years ago. But I think for those of you who are interested in access to justice advocacy, as I know many of you are, I think it's really important not to forget how absolutely crucial it is for change that people believe that change is needed. Obviously that is not the change, but there's not going to be any change until that belief is widely shared among people who can make something happen. And so we spent quite a bit of time in our report simply trying to make the case that yes, this is real. We need some serious revision of the way we're doing business here. And so a big hunk of our report at the beginning is devoted to that. What we did in terms of the fragmentation is that we proposed that every jurisdiction, every province, every territory ought to have a multi-sector access to justice committee or commission or whatever. We didn't really care what it was called. But what we felt was very important was to try to bring all the players together with some public input so that they could address common problems with common strategies. And I believe that kind of policy alignment within government and beyond government is crucial. And I'm happy to be able to report to you that every jurisdiction in Canada, I think with one exception, has created a body along those lines. And we convened a meeting of representatives of those groups for the first time last March, and we're having our second one next month. And although those groups are just really getting going, I think that if they do perform their roles well, they have the potential to transform the way we think about justice reform, because everybody is around the table, and that has not been happening in the justice system in many places in the country until very recently. The other thing that we identified as a fundamental problem is the culture. We felt that there needed to be significant culture change in the orientation of the civil and family justice system. And I know it's very easy to talk about culture change, but we at least went on and tried to put some actual meat on those bones. Came up with 6 principles that are easy to state, and yet we believe will have significant impact if taken seriously. And of course, we put them forward in the spirit that if you've got better principles, then let's hear them. We weren't handed these on tablets of stone. A bunch of people came up with these, and there may be better principles. But here are our principles. Number 1, put the public first. Duh. Who do we think we're trying to work for? But it's amazing how often in our approach to civil and family justice reform, the public who are using the system are kind of the last people we get around to talking about what their needs and expectations are. Second of all, collaborate and coordinate. We felt that there was these problems of fragmentation in the leadership were very serious and impeding meaningful change. And so we think that we need to move from a culture of independence to a culture of collaboration and coordination, while respecting constitutional roles, of course. But the constitutional requirements don't prevent meaningful collaboration. Third principle, prevent and educate. We feel that a lot of our problems could be addressed at a much earlier stage. That by the time the judge has 2 parties in front of him or her in a courtroom, a lot of water has gone under the bridge. And we feel that prevention and better education, I know in the public legal education world, the term legal competency is used very often nowadays. The idea is, do people have the information that they need to recognize a legal problem when they have it, and to know where to go to do something about it before it cascades into a whole series of other problems. Fourthly, we said simplify, make coherent, proportional, and sustainable. And again, those are easy words to say, but if applied, I think they could be very powerful in our approach to many of the ways that we do business, certainly in the formal system. Fifth is to take action. Obviously, all the talking, all the committees, and all the rest of it don't really change anything. We need to act. And then finally, I think we propose that there needs to be a greater focus on practical outcomes. In other words, while of course preserving the fairness, protecting people's rights, and so on, it's very important that there be something practical for them at the end of the day. So those were our 6 principles, and we felt that if those principles are added or modified as other people might wish to do it, really drove what we were doing in civil and family justice, there would be a significant change in our attitudes and or in other words, in our culture. So those are the kinds of things that we spoke about. We also set out 9 justice development goals in the report concerned with innovation, with simplification of systems, coordination of systems, and also research and funding, because the state of our empirical research about the way the civil and family justice system works in Canada is at a very beginning point. And so if anyone's interested in more detail about some of the things we thought should be on that roadmap, you can have a look at the report. But I thought I would emphasize in my brief comments this evening some of the more structural things, because I think those are some of the things we often don't talk enough about in civil and family justice. And yet we came to the conclusion that those are largely the factors that explain why we've had this big gap between ideas and action over so many years. The other thing that I struggle with in the work on access to justice is this, that if you read a lot about change and how to make it happen, a lot of that literature says you've got to have a crisis. And I was talking to a business leader the other day, and he said, yes, you've got to have the burning platform before anything, you know, the flames have to be sort of licking up around your heels before anything will change. Well, I hope that's not true, because I don't want it to get to that point in the civil and family justice system. But moreover, I also fear that the kind of change that crisis mentality will result in will not be the fundamental systemic change that I believe the system requires. I fear that what will happen if we simply convince everybody that there's a huge pending disaster, that what will happen is a lot of money will be spent that will help the problem for a year or two, and then we'll be back to business as usual. And so I always feel I'm walking this kind of delicate line between, on the one hand, making sure people understand that there is a serious problem, but also trying to encourage a systemic, long-term approach to solving the issues. Because I think that we are confronted with a very complex system, and it's going to take a long-term, sustained effort to bring it around to where I think it should be. So those are some of the things then that we talked about in our report. Let me turn to the final question, and that's what can you do? And I'm addressing this not only to law faculties and members of the legal profession, but also to members of the broader public whose job it is not to run the legal system, but I hope have an interest in it. Speaking first for the law schools, because I know many of you are, how many of you, if you don't mind me asking, how many of you are law students here tonight? Okay, quite a few. And so I feel justified in saying a few words directed especially to law schools. Here's the dean is really looking forward to, oh good, some more things we can do. But anyway, I'll try not to make the list too long, Camille. And I know you have a very strong background and commitment to access to justice, so I feel entitled to say some of these things in your presence especially. I think the university traditionally is built around the three pillars of teaching, research, and community service. And each of those is a very rich area for contribution to access to justice. In terms of teaching, I'm really pleased to see that a number of schools have started access to justice courses and seminars where students are helped to be better informed about what are the issues in access to justice, what's some of the current thinking about how access to justice could be improved, and so on. And of course, many schools are building an access to justice perspective into the law school curriculum, and I certainly applaud that. And another area where I suspect not quite as much is being done, but I think is very important, and that is helping students prepare to develop those more non-traditional ways of practicing law that will really improve access to legal services, but in a way that will also make a decent living for the students after their long and expensive sojourn in school. That's one area where I'm not so sure we're as far ahead as we should be. There are some quite exciting models about how legal services can be marketed to the public in more cost-effective ways, and I certainly would love to see even more being done along those lines from a teaching and learning perspective in school. From the research perspective, you just have an open field of possibilities. The justice system is in a lot of need for more empirical work. How does the system actually work? One of our wonderful and much loved senior colleagues at the Dal Law School, when I first joined the faculty back in the early 80s at the age of 11, was Robert Samek, who was a legal philosopher. But Robert had a wonderful sentence that he often said, and that is, law isn't what it says, it's what it does. And the problem is that we often don't really know what it does. And so there's just a huge area for empirical research in law, and especially, I would say, in civil and family justice. Do the reforms we're trying actually make people's lives better or not? And how do we know, how do we judge that? So there's a huge area of research open there, which we're just starting to move into. There's also a lot of need for research on how we evaluate the effectiveness of change. We need much more practical ways of assessing whether our efforts are having the desired results, and there's a lot that I think the research community can contribute there. We also have many opportunities to reach out to other disciplines, because I think that, and you'll see from what I've said so far, that I believe that a lot of our most fundamental problems in civil and family justice are concerned more with change management and promotion of innovation than they are with particular rules of civil procedure or particular aspects of particular laws. That we have a much more complex system issue, and frankly one that most lawyers are not, including this one I would add, are not particularly well equipped to address. And so I think we need to redouble our efforts to reach out to other disciplines who are more sophisticated in their understanding of complex systems and how those systems can change and innovate. So there are many opportunities for research. Service, of course, is the one that I'm sure almost all of you have already encountered. I think our law schools are doing a lot of wonderful work through clinical training, clinical opportunities, legal aid clinics, and so on. I think our law schools have really picked up the pace there. Dalhousie, of course, being virtually a national leader. I think the first legal aid clinic, am I right, Camille?
So.
I think it was the first student-run legal aid clinic in the country. Many other schools have done that. When I do my law school visits, I always try to meet with the students who are doing clinical law, and it's a large and enthusiastic group. So there's lots of great public service there. But maybe we could even think about other things to do. Could a law school, for example, run a not-for-profit law practice? By the way, if you need any experience, any help with running a not-for-profit law practice, I'd be happy to drop by, because I did it for a few years. But seriously, one of the things that people are talking about in trying to make legal services more accessible is to set up a not-for-profit model for law firms so that the lawyers would make a decent living, but that the services could be offered at more reasonable rates. Now obviously the devil is in the details in all of these things, but is there any role for law faculties in promoting or maybe even hosting or helping to host something along that line? There may be many other things that could be considered. Another area I think law faculties could help, and that's why I was particularly pleased to see the way you arranged this evening, was that I think law faculties are well placed also to do more public outreach. I know that certainly the Dal Legal Aid Clinic has always had a public outreach component to it, and there are many more public outreach aspects of universities, and that might be a way to try to engage some of the public more fully in the importance of access to justice, because after all, without a broader public conversation about access to justice, I think it's going to be difficult to bring about the kind of change that we have. So there are a few ideas, and for members of the public and others who are not directly engaged in the legal system, I would suggest the first thing is perhaps to become a little better informed about some of these issues. I suggest to you that access to civil and family justice is a significant public concern and should be, and I'd like to see it more broadly discussed among people who are not insiders in the system. So I think some better information would be good. Better informed people would help us. And second of all, that if you're asked to give a hand with an Access to Justice project, think seriously about getting involved in it. I know that many of our Access to Justice groups across the country are actively trying to engage in a more broad way with members of the public. And of course, that's also going to take their willingness to give that group a hand. So there are at least a couple of ways that I think that everyone could take a bigger part in trying to improve access to civil and family justice. So just to wrap up, I would say this, that we in the legal system, those of us who are the insiders, and I use that in a very wide sense, not just lawyers and judges, but all of the people who work in one way or another in the legal system, we all need to do a great deal more to provide the leadership for change that we need, I think, to move from talk to action, to help overcome that implementation gap. And perhaps we can devote a little more time to thinking about how everybody could be part of that sort of discussion. And just to change gears for a moment in terms of accessibility and people feeling that they have some recognition of the legal system, let me just leave you with this little anecdote. Somebody wrote not that long ago that more people could identify Santa's reindeer than could identify the 9 judges of the Supreme Court of Canada. I've had occasion to be grateful for that. But let me tell you about something. Probably most of you know that my colleague Justice Rothstein recently retired from the court and has retired to Vancouver. And not that long ago, I was driving around in rural Nova Scotia and stopped for a coffee. And when I finished, I went up to pay, and the lady that was at the cash register said, "You're on the Supreme Court, aren't you?" And I said, "Oh boy, here's the start of another perfect afternoon." But anyway, I admitted that I indeed was, and she said, "It's a real pleasure to meet you, Justice Rothstein." So we had a nice conversation for a little while, and then she asked me, "What's the best thing about working at the court?" And I said, "Getting to work with Judge Cromwell." So she had access to justice in a certain way. But anyway, that's all I wanted to say to you this evening. I know you've got a big day tomorrow. I think we're going to have a reception, and I hope I'll get to speak to some of you informally in that context. And I just want to thank again the organizers for giving me the opportunity to talk about something that's dear to my heart. And it was also a special privilege, if I may say so, to have the father of one of my former students here to get the night off to such a wonderful beginning. So thank you. Thank you very much. Good conference.